Hey, I'm firearms attorney Gilbert Ambler, and today I want to talk to you about the nasty tactics that anti-gunners are using to try to avoid losing Second Amendment cases where gun restrictions could be found to be unconstitutional. But before we dive into that, if you have not yet hit subscribe, go ahead, hit subscribe for us, like this content, share it, tell your friends. That way you and your friends can keep getting this pro-Second Amendment related content. So what we're talking about today is the shift that we have seen take place since 2022. As most of you know, in 2022, the Supreme Court of the United States handed down a monumental decision with New York State Rifle and Pistol Associations versus Bruen. And in that case, they shifted the burden. The burden used to be on the challenger. If we challenged the law under the Second Amendment, it used to typically be a burden on us to show that the law was unconstitutional, and the government was typically able to win simply by saying, this law promotes public safety. In most parts of the country, judges would buy that argument and would find a law to be okay even if it infringed on Second Amendment rights. After Bruen, however, the burden shifted. Now if we go into court with a Second Amendment challenge, as long as what we're challenging falls under the clear text of the Second Amendment, the burden shifts to the government to demonstrate that their restriction is constitutional under what is known as the text, history, and tradition test. And no longer can the government win under this test simply by saying we're furthering an important governmental interest. And so what this means is it means Second Amendment challenges have real teeth, and for that reason you're starting to see gun restrictions fall all over the country. However, anti-gunners and the defenders of these firearms restrictions know that when it comes to a Second Amendment argument at this point, they're on losing ground. So they're using a couple of really sneaky tactics to try to avoid arguing about the Second Amendment. And what you'll see when they file a brief on a Second Amendment issue, a very, very small portion of the brief will typically be devoted to the Second Amendment, and much of the brief will be devoted to something like standing. Standing is a concept in all cases. There has to be standing for a court to hear the case typically. And what they're looking for is they're looking for things like, is there harm? One of the tactics that we've seen repeatedly used when there's a firearms restriction in place is if somebody sues to try to end that restriction, the people defending the law will claim that there is no harm if the person suing has not been arrested for violating the law. That's right, they say, yes, we've got this law in place and we don't want you to challenge it unless you actually get arrested, okay? Now imagine the position that puts somebody in who wants to challenge the law. The politicians are saying, if you want to bring a constitutional challenge to this, you need to come in, you need to actually get yourself arrested in order to challenge it. Now fortunately, judges across the country have looked at the case law on this and have allowed challenges to move forward even when there's not an arrest, as long as there is a sufficiently imminent threat of prosecution, okay? That's what we're typically looking for. Is there an imminent threat of prosecution? Nonetheless, this highlights a tactic, right? Because the tactic is, say there's not harm because you haven't actually been arrested, and of course, who wants to be arrested? Another tactic that we're seeing used over and over again with standing is a situation where someone will try to moot a case. And of course, in mooting a case, I'm talking about removing the harm. So this would be something like, if you've been denied a license to carry. This is going on in North Carolina right now. There's a sheriff in North Carolina that Gun Owners of America has repetitively had to sue him over and over because he repetitively violates people's rights when it comes to obtaining a concealed carry permit. But if you sue saying that you're being harmed because you deserve a concealed carry permit and this particular sheriff is refusing to issue it to you, what we're seeing is a tactic where the sheriff would go ahead and would issue these concealed carry permits, because by issuing them, he's then able to go into court and say the person challenging the law is not actually harmed because I've given them what they're asking for. I've given them their concealed carry permit. So again, this is another example of where we see this tactic in play, where they're trying to argue about standing and harm and mootness and not trying to argue about the Second Amendment, because the risk for them when they start arguing about the Second Amendment is that if they lose the case, it might establish precedent to the contrary, and that would affect everybody else across the state or even across the country, depending on what level they lose at. So what we're seeing is just tactics, delay, and manipulation to avoid actually talking about Second Amendment issues. One final thing that I want to talk about, one final trick that I've seen, is they're trying to sort of bend or mold the test. Because the Second Amendment applies to the people, right? It says the people, and we know that the people, we know this from Heller and McDonald, means an individual right to keep and bear arms. And it says that the people have this right to keep and bear arms, and that it shall not be infringed. But what we're seeing elsewhere is we're seeing anti-gunners try to manipulate the term the people. And what they're saying is the people means law-abiding people. And so we don't have to use a Second Amendment test. You don't have a Second Amendment right if you're not a law-abiding person. But this is a very dangerous standard, okay? And personally, I totally disagree. I think that the people means everybody, and we then use the Second Amendment test to decide how much protection under the Second Amendment someone who would get who is a member of the people. But if we allow this term to be manipulated to mean only law-abiding people, we give the government the power to declare who is law-abiding. And let me show you how this could play out. For example, we've been talking on this channel an awful lot about pistol braces because the government has said that braced pistols are really SBRs, and if you have a braced pistol, you are in possession of an unregistered SBR. If you're unfamiliar with this, check out the other videos we have. But watch how the government could manipulate this. Because if we come into court, and we are in court arguing about braced pistols and challenging it on Second Amendment grounds, an argument the government might try to make in this case is to say, well, the Second Amendment only applies to law-abiding persons, and if you're in possession of an unregistered SBR, you're not a law-abiding person, and therefore you don't deserve Second Amendment protection. So you see how this test that the government, the way they're trying to frame it, the way they're trying to phrase things, they could try to make it so that it's sort of a self-fulfilling prophecy. They get to determine who's law-abiding, and they then get to use that term against you to avoid giving you Second Amendment rights. So these are just a couple of the tactics that we've seen. I'm going to try to keep you updated on trends like this that we see happening in court cases. If you enjoyed this content, like, comment, share, tell your friends. Until next time.